All rise. The International Criminal Court is now in session, hosting the ICC Moot Court Competition 2025 Chinese edition. Please be seated.
Good afternoon, everyone. I'd like to greet the teams participating. First, counsel for the prosecution. Second, common legal representatives of the victims. And third, counsel for the defendant. I welcome as well the courtroom staff and the security officers who diligently assist us all in our work. And also, I greet the interpreters. I should also greet those in the public gallery, the participants in the ICC Moot Court competition, attending this hearing, and those outside the court joining us this afternoon via the internet in this Moot Court competition. I would now turn to the court officer and ask that she calls the case, please.
Thank you, Mr. President, Your Honors. We are sitting in the appeal session regarding the pre-trial chamber's denial of confirmation of charges in the case of the prosecutor versus Alex Vraga in the situation of the Republic of North Eros, ICC Moot Court Competition 2025 Chinese edition.
On behalf of the Chamber, I'd now ask the parties and participants in this hearing to introduce themselves, beginning with the counsel for the prosecution, which brings this appeal. But before you start counsel, I'd like to ask the parties and participants to speak slowly and to pause before responding to any question in order to allow all participants to follow closely and also for the interpreters. Could I ask you, counsel for the prosecution, to present the members of your team?
Your Honor, I am Prosecutor Liu Xingzhi, and this is my researcher, Chen Wangyang.
Thank you. Now I turn to the common legal representative of the victims participating under Article 68.3 of the Rome Statute. Could I ask you, the counsel, to present the members of your team?
Your Honors, I am counsel for the prosecution, the counsel for the... This is my colleague Zhou Tingting, Duan Wen, Han Jingyi, Zhang Yingxi, Ji Feiyang, Cui Wenbo. Thank you.
Thank you. I now turn to the counsel for the defendant. Could I ask you, counsel, to present the members of your team?
Your Honors, counsel for the prosecution, counsel for the witnesses. I am the counsel Li Jiayu. Beside me is my researcher Zhang Ziyu, and behind us are our advisors Zhang Yue and He Yixing, as well as researcher Xu Mingyao. Thank you.
Thank you. The team of the registry is represented today by the court officer Antonia Nowak and timekeepers Feng Yiwen, Tang Xi, and Chang Shi-tao. Finally, I'd like to introduce the bench. To my right is Bolani Olupona, and to my left, Victor Sibaha, and I'm Judge Ki Bong Baek, and will be presiding today's hearing. The Chamber will now proceed consecutively with the three issues shaping the subject matter of today's hearing. Being mindful of the public nature of this hearing, I'd ask the court officer to please read the agenda established by the Appeals Chamber.
Thank you, Mr. President. Pursuant to Pretrial Chamber 15's decision to grant the prosecution's request for leave to appeal the denial of confirmation of charges of 15 September 2024, the Appeals Chamber seeks submissions of all parties and participants on the following three issues. A. Whether the pretrial chamber erred in finding that the ICC lacked jurisdiction over Alex Fraga under Article 12(2)b of the statute because he lacked a genuine link to Pentos, a state party to the Rome Statute. B. Whether the pretrial chamber erred in finding that the allegations and evidence are insufficient to establish substantial grounds to believe that Alex Fraga aided and abetted the commission of the inhumane act of gender apartheid under Article 7(1)k and Article 25(3)c of the statute. C. Whether the pretrial chamber erred in finding that Alex Fraga cannot be tried for committing an offense against the administration of justice under Article 71(c) of the statute when the web platform that he created and controlled published a confidential document hacked from the ICC that included the names of anticipated witnesses in the case.
Thank you, court officer. I will now turn to the prosecution to present its submissions on the same three issues of the discussion. Thank you. You have the floor, prosecution.
Your Honors, I'm the counsel for the prosecution, Liu Xingzhi, and this is my researcher, Chen Wangyang. In November 2021, the Belarusian regime issued 4 decrees in the Republic of Northros, restricting a series of women's rights, leading to a mass exodus of civilians to Northros. The defendant, in this case, Fraga, holds dual nationality. He led the development of ABSS system, which was used to intimidate and shoot civilians in Northros, preventing them from leaving the country. The prosecution's legal argument comprises 3 parts. First, the court has jurisdiction over this case. Second, there are substantial grounds to believe that Fraga committed the crimes of aiding and abetting gender apartheid under Article 7(1)k and Article 25(3)c of the statute. Third, Fraga committed an offense against the administration of justice under Article 71(c) of the statute. Regarding the first issue, the prosecution argues that the ICC has jurisdiction over this case under Article 12 of the statute. The overall reasoning is as following. The pretrial chamber erred in applying the sufficient link standard, and the prosecution asserts that the ICC should recognize the nationality granted to the defendant under domestic law as valid, thereby establishing ICC's personal jurisdiction over this case based on the defendant's nationality as a state party to the statute. First, the ICJ stated in the Notenbaum case that nationality can only be recognized when the connection between an individual and the state reaches a certain level of sufficiency, and it is only related to diplomatic protection. To begin with, the ICJ proposed the sufficient link theory solely to test whether nationality could serve as a basis for diplomatic protection. It is important to note that the ICJ did not intend to establish a universal rule for determining the validity of nationality. The conclusion was strictly limited to the facts of that case. And every country can decide conditions for granting nationality. Second, even within the field of diplomatic protection, this standard is highly controversial. For example, the Flagger-Mao case and the Micheletti case both rejected the application of sufficient link and described it as questionable. In fact, it's very dangerous to apply this standard. For example, in the draft articles of ILC, since we live in a globalized world, many migrants, they have not established connections with the place they moved to. They cannot enjoy diplomatic protection. So we cannot apply this standard, which is even controversial in the area of diplomatic protection. Secondly, the ICC the Article 12 doesn't have any additional conditions for personal jurisdiction, and ICC should recognize Viraga as a national of Pentos based on Pentos domestic law. First, if we interpret the text of the statute, it doesn't require us to determine the nationality of the person in question. In the situation of Bangladesh, it explained that as long as certain elements of the case happened on a state party, even if other elements didn't happen in the state party, and then the court has the jurisdiction over the whole case. Therefore, in this case, as long as the defendant has the nationality of one state party, even if he has other nationalities, then we can apply personal jurisdiction to proceed. And here I would like to kindly remind the chamber that the defendant might erroneously believe that we need to interpret the statute based on Article 36(7). However, this provision is to ensure the participation of all state parties, and this is not really related to the jurisdiction of the court over this case, and they are not really of the same nature. Therefore, in this case, jurisdiction, in particular, personal jurisdiction, should be exercised, and that is more appropriate. Lastly, based on the purpose, in order to prevent impunity, the ICC must exercise jurisdiction over the national's nationality. Therefore, the ICC has personal jurisdiction over this case. Regarding the second issue, we believe that we have substantial grounds to believe that Viraga committed offenses. Article 7(1)(k), which is aiding and abetting gender apartheid. First, the gender apartheid constitutes an attack against the civilian population, and this is part of the crimes under humanity. And then we have substantial grounds to believe that Viraga should be charged. To begin with, the gender apartheid can fall under crimes under humanity, as it is part of the inhumane treatments, and it has met the elements of crimes which are objective and subjective elements. And this case meets the background element. This is a national policy which is widespread and systematic attack on women. So this gender apartheid constitutes an attack against the civilian population. In the case of Hassan, ICC already affirmed that this kind of attacks can be regarded as a crime against humanity. In this case, the background regime issued 4 decrees and demanding all women living in that country to comply with all the decrees. Second, the attack was carried out to implement a state policy. In this case, the background regime had explicit decrees, and so that satisfied the element of policy. Third, the attack was widespread. If the number of victims, the frequency of attacks, and the duration of attacks have the cumulative effect and have resulted in a massive impact, the attack is considered widespread. If we look at the number of victims, we can take the situation of Kenya as an example. The number of victims was 4,000 and was already deemed as massive by ICC. However, in this case, more than half of all women living in Northern were impacted. Therefore, the scale has already reached the threshold of massive. In terms of the frequency of the attacks, the 4 decrees have been implemented on a long-term and continuous basis since their issuance. In terms of duration, the attacks in the Gabo case were determined to have lasted for a long time, despite only spanning 4 months. However, in this case, this duration has already been nearly 4 years. Therefore, in this case, the attacks exhibit widespread scope. As such, all the elements have been met in this case. Second, this case meets the special element. The conduct must satisfy 2 elements. First, the perpetrator caused serious harm to the physical or mental health of a person, and the nature of the conduct is the same as any other conduct mentioned in Article 7.1 of the statute. To begin with, the Akayesu case noted that causing serious harm means the harm must have a significant and a long-term adverse impact on the individual's ability to lead a normal, constructive life. In this case, a high number of deaths among those who fled and the threat of flogging for those who violated the law demonstrate that the law has caused serious harm to the physical health of the population. Additionally, the court deprived women of their multiple rights, such as right to health, right to education, and the right to leading a normal life. At the same time, in the whole society, it has created an atmosphere of discrimination. Therefore, the gender appetite has caused serious harm to its people's mental and physical health. Second, the nature of gender appetite is the same as that of other acts under Article 7.1 of the statute. Nature refers to the essence and severity of the act. The essence of acts under Article 7.1 of statute is a violation of fundamental human rights and international human rights law. In this case, the 4 decrees have violated multiple rights, including right to education, the right to employment, and the right to freedom of movement, and the right to free of discrimination enjoyed by women. Therefore, the act is essentially the same as other acts under Article 7.1.
此外，
In addition, the behavior under consideration is similar in its degree of severity. It is a system of systematic oppression of women and the establishment of an overall atmosphere discriminatory against women, which constitutes serious harm, excluding them from education and equal dialogue. This is similar in severity to apartheid as laid out in Article 7.1j of the statute. Finally, this case also meets subjective criteria. The accused must be found to be conscious of the severity of the acts or their potential results. The accused's position allows them to have constructive knowledge of the results of their acts. That is why the United Nations Human Rights Council has already called for the abolition of the 4 decrees. In summary, the acts constitute gender apartheid contrary to Article 7.1k of the statute. I would like to ask the Council a question, and I will do that in English.
I note that the prosecution's evidence to support the charge of gender apartheid consists of an NGO report. What factors should the Chamber consider when assessing its probative value at this stage of the proceedings, namely the confirmation of charges stage? Thank you.
Thank you, Your Honor, for the question. Firstly, the current stage of proceedings requires that there are substantial grounds for belief. And indeed, the question of the probative value of an NGO report is at hand. Its evidentiary value, its relevance, the consistency of information and reliability of information must be considered by the court. Now, in Bemba and Abu Jarda, these criteria were confirmed as criteria for assessing evidence. I will first move to the evidentiary value of the report. Firstly, it has a high degree of relevance with its detailed description of gender apartheid crimes and the degree to which Vraga's acts enabled those. Secondly, the information is reliable. Human Rights International has sourced information from public reports and directly from witnesses, 2 witnesses in particular. And in the Bemba case, a report was relied on from the International Human Rights Alliance. And again, it was reliable, transparent, and from clear sources. Now, it is clear here that the accused had a clear role in the 2 people from whom the evidence was sourced had a clear role in the company, and there's no contradiction between their evidence, and so the probative value is high and suffices to establish prima facie grounds for Mr. Vraga's crimes. Thank you.
Counsel, before you move on, it's not clear to me exactly how the 4 decrees constitute an attack within the definitions of Article 7.1k of the Rome Statute. Could you speak further on that?
Thank you, Your Honor, for the question. Firstly, there are clear elements of crime set out for Article 7.1k offences, and we have dealt with those in turn, but I would like to refer to the Mongmont case, and that case refers to an instance of forced marriage. In the jurisprudence of this court, it was held to be a crime against humanity under Article 7.1k. In the judgment, the court held that the essence of this act was placing the victims in an insulting position and depriving them of their freedom of marriage and putting them in a humiliating position and creating an overall atmosphere of discrimination. The 4 decrees in the case at bar have deprived women of their freedoms of education, employment, and migration, and have created a discriminatory atmosphere across society, leaving women out of meaningful participation in society, constituting a serious damage to their dignity and position in society, and thus in line with previous practice of this court, it should be held to be acts that meet the criterion of Article 7(1)(k). Thank you very much. Now, on a second level, Frage's case meets the objective and subjective criteria laid out in Article 725(3)(c) of the statute, because aiding and abetting the Ballarat regime's gender apartheid leads to criminal responsibility for Mr. Frage. Firstly, the objective criteria are met. The defense may have erroneously argued that Mr. Frage should have helped the Ballarat regime. Now, we would submit that it is only necessary to have aided and abetted crimes, not specific people. And Mr. Frage provided substantial help to the prevention of people from fleeing Northaros. Furthermore, this action must be held to have abetted or assisted the commission of crimes. Large numbers of civilians were prevented from crossing the river to leave Northaros. This led to the application of the 4th decree, which provided assistance to the commission of the crimes. So the objective criteria are met, as well as the mens rea. Mr. Frage's acts were carried out with a clear intention to assist this criminal activity. In his contacts with the government authorities, Mr. Frage cannot have failed to realize that this cooperation was in furtherance of criminal activity. Now, the defense may erroneously argue that Mr. Frage was motivated only by economic interest and execution of a contract, but the operative logic of the ABSS system is sufficient to infer knowledge of the criminal intent. Please refer to page 8, section 8, and also at page 9, paragraph 12 of the problem. All people, all civilians attacked by the ABSS system were subjected to grade 1 injuries, and it is clear that this is a highly accurate system which was principally aimed at killing civilians. This in itself shows the mens rea of Mr. Frage, and that is why he must face criminal liability for gender apartheid.
Counsel, may I ask a question? You explain in terms of objective elements and subjective elements, but I understand the defendant was involved in the border control system of South Eros. but can you elaborate more on the connection, not with the South Eros, but the North Eros regime? So your explanation seems to me still distant from the core of the regime system. How do you describe the action of the defendant is connected to North Eros regime in terms of subjective and objective elements to prove his actions, to confirm the charges?
好的，感谢法官的提问。
Thank you, Your Honour.
首先，就客观要件而言，
Firstly, in terms of objective criteria,
便利犯罪实施的目的，
it is sufficient that the accused actions provided
特性极
or facilitated
建设在
the overall goal. Now, the installation of the ABS system with a high degree of deterrence on the border
诺国女性出于害怕，只能
is sufficient to
在诺国的
create an atmosphere of fear among North-Eros women and a sense that they could only remain within North-Eros. And that facilitates the execution of Decree number 4,
巩固和
requiring that they stay within North-Eros and
在主观要
creating a sense of oppression. Now,
原法院
in terms of subjective criteria, the court is not required to
享有
find
犯相同的
that
在
Mr. Varga had a similar degree of intentionality to the principles. In Forenza, the court has already held that it is sufficient for the accused to know that his acts may
主观要件，
end up facilitating the
设置 A、B
criminal actions
就是为了
for
威慑
him to bear criminal responsibility. And
那么这是
it is clear that Mr. Faraka was aware that his actions could lead to the deterrence of North-Eros women from leaving the country.
就第三个争议问题，
In terms of the third issue at hand, the prosecution
或作证
would argue that
首先
Mr. Fraga
被告
is
行为满足客观要件，
guilty of obstructing the course
本
of
案当中
justice.
公开报告的行为直接破坏了证人身份的
The
匿名性，
Release of the unredacted report
恐吓形式。第二，
led to intimidation of witnesses and removed their anonymity.
弗莱格在报告被公开后，
Secondly, Mr. Fraga, after the publication of
在
the
给检方律师
unredacted report, sorry, may I ask for 3 minutes in order to finish my arguments? Your Honour.
Okay. Proceed, please.
感谢法庭。
Thank you, Your Honour.
弗莱格有意干扰证人，
Mr. Fraga intentionally interfered with
公
witnesses.
开了证人姓名，
Mr. Fraga
在报告
published
公
the
开之后
witnesses'
从未采取行动
names
删除。
and took no action to redact their names from the published
报
report.
告当中明确提到，
Mr. Fraga
证人参与
cannot be
案件
unaware
判
that
证人姓名已从公开版本中隐去，
in the practice of the ICC,
能够
the names of witnesses are normally redacted and thus must be aware of the deleterious effects of
以上就是
releasing those names. That therefore constitutes obstruction of justice. Thank you very much for your attention.
Thank you, counsel, for the prosecution. Now I will give the floor to the common legal representative of the victims to discuss the issues on the agenda of this hearing. You have the floor.
Your Honours, Counsel for the Prosecution, Counsel for the Defence, my name is Liu Shuxin. I am the head of Team 25090, and this is my colleague Zhou Qingqing. I will make submissions on the 3 main issues at hand. Counsel for the victims will make additional submissions complementing those of the prosecution, and We'll also address the issue of compensation for the victims under Article 75 of the statute. Referring to issue number 1, we are of the view that the ICC has jurisdiction in personam under Article 12. Firstly, the principle of equality is applicable to this case. Secondly, the genuine connection principle is not applicable to this case. And thirdly, there is a direct, insufficient connection between Pantos and the defendant. Firstly, the principle of equality is applicable to this case. Every state of nationality is equal, and thus all states may exercise criminal jurisdiction over their citizens. ICC's jurisdiction comes from authorization by treaty states, and thus it is sufficient for one of those states to be a signatory for the ICC to exercise jurisdiction over their citizens. Through interpretation of the treaty, it is clear that the principle of equality also applies to dual nationality as concerns the ICC. Firstly, the context is important. Article 36(7) of the treaty states that citizens with dual nationality are able to exercise and enjoy the rights of both nations. If only one is selected, then that is a more restrictive approach, but Article 12 does not adopt this approach. Secondly, the overall goal of the Rome Statute is to avoid impunity. Thus, in line with the overall goal of the statute, possession of another state's nationality should not exempt an accused from the jurisdiction of the court. The principle of genuine connection under the Nottebohm case is not applicable to this case. Firstly, genuine connection has not become part of customary international law. This principle does not meet the three objective criteria. Now, the Council for the Prosecution has mentioned that it is restricted to diplomatic protection. It is not otherwise a customary principle of law. We are also of the view that this principle has been followed relatively seldom. For example, in the international investment dispute, Sabah versus Turkey, the arbitration tribunal rejected the genuine connection principle, and thus it is not part of customary international law. In addition, the background facts of this case are very different to those of the Nottebohm case. Firstly, in the Nottebohm case, this was a case about diplomatic protection. The case at hand is about international criminal law. Secondly, in the Nottebohm case, the crux of the case was state responsibility for international diplomatic protection, whereas this case is about individual responsibility. Thirdly, the disputed nationality in Nottebohm was acquired by a series of planned acts, whereas in this case, both nationalities are the result of circumstances of the accused's birth.
A third reason, sufficient link exists between Pantos and the defendant. The International Law Commission has identified place of birth as a sufficient link for the granting and recognition of nationality. In this case, Pantos, as the place of birth of the defendant, is sufficient to establish a link with the defendant. Regarding the issue 2, we argue that defendant committed the inhuman act of aiding and abetting gender apartheid, and we have 3 reasons. First, his act is can be considered as aiding and abetting
理由一，
gender
巴勒兰政策
apartheid.
性别隔离构成规约第7条一款
First, the gender apartheid of Belarusian regime constitutes other inhuman act under Article 71K of the statute.
主观要件、
The prosecution
客观要件
has
当中的攻击
already
及广
talked
泛
about
性
objective and subjective elements in the statute,
我方赞同
and for example, the comprehensive characteristics of the attack, and we agree with the prosecution. And here we would like to talk about the nature, the sufferings,
大几点补充。
etc.
就性质而言，
About the nature,
性质
according to
本
elements,
质
nature means the gravity and essence of the conduct.
基本
The nature of the act
在本案
has
中
violated and human rights.
基于
In this case,
基于其不同
the
的
gender apartheid violates the rights of women
保护女性平等
based on its sex,
权利、工作权、
and it has violated the right to work, the right to education, the right to freedom of movement of the women in Northwest.
2023年的哈桑案当中指出，免受
ICC in the El Hassan case of 2023 stated that
行动自由
the right to work, the right to education, the right to freedom are the basic human rights according to international law,
公约被认为
and
是基本
those rights are recognized as basic human rights by many conventions as well as UN resolutions. For example, the right to work, the right to education, the right to leave one's own country are considered as basic human rights in Article 2 of the Convention on the Prevention and Punishment of Apartheid.
性别隔离所导致的歧视和压迫结果
And
和规约第7
the
条1款这一项的种族隔离是相同的。
the consequences
和种族隔离的
from the
另外一
gender segregation and oppression in the same way as apartheid under Article 71J of the statute.
排除在公共参
It's the same way as the victims of apartheid.
就业
So the women in Northwest were subjected to unequal treatment.
严重程度层面，
So is
在重大痛苦
has the equal gravity.
我
Second,
方赞同检方刚刚所提出的标准，
the act has causes significant suffering and serious harm. We agreed with the prosecution.
和建设性的
The significant suffering requires more than temporary misfortune, making it difficult for a person to lead a normal
不
life.
仅造成女性的重大痛苦，
It's important to note that gender segregation causes significant suffering not only for women but also for
法
men.
官可以注意附录 B 的第7段。
I would like to draw your attention
本案
to the paragraph 7 and 8 in Appendix B.
冒着死亡率高达80%，
Thousands of women,
也要逃
men
往
and children fled to Southwest at the risk
成功逃
of
出
morality rate, and even they succeeded in escaping
生活条件恶
to
劣
the other country. They faced the lack of access to education, poor living conditions, and severely compromised physical and mental health conditions.
所遭受到
So
的
it's evident the victims suffered significant physical and mental pain under the policy of gender apartheid.
是对性别隔离的帮助和教唆。
The second reason, the defendant's conduct was an aiding and abetting of a gender apartheid.
教唆行为，要求
In the case of Bemba,
犯罪实施，
the act of aiding and abetting requires that it contribute to facilitating the commission of the crime. In this case, Vraga provided ABSS to carry out the shooting, making it difficult for the victims who wanted to flee the country to get rid of policy of gender apartheid.
Sorry, Council, I have a question. So you were just a few seconds ago, you were saying that men were subjected to floggings in the application of this regime. Isn't it your submission that gender apartheid is targeting victims on the basis of gender? So if my understanding is correct, then why would men in this case be considered victims of gender apartheid? Thank you.
尊敬的法官，
Your Honors,
我方主张，被
it's
害
our
人
position
不仅只
that
是直接受到
the victims are not only the direct victims of their policies, so in this case, women.
在卢班加案当中指出，
In Lubanga case,
间接伤
the
害
ICC stated that indirect harm
要求，例如
is also very important. Is, for example,
法庭将被招募的儿童兵的父母
the children soldier who are recruited, the parents of recruited children soldiers are also victims. So in this case,
等家庭成员所受
the
到
wives and the daughters of men
同时也会受到重大痛苦。
fled to another country, so the men are also victims.
作为与诺国
It's
的
our position,
存在密切联系
and the
的
men
亲属关
and
系，
have a very close connection with women, so the men are also considered to be victims. Thank you.
在主观要件层面 ，ICC 在本案中认为，
In
帮助和教唆的意义
subject of
求
elements,
帮助教唆者意识到主要罪行会在正常情况下发
the
生。
ICC held in Bamba that intent to aid and abet requires that the aider and abetter be aware that the principal offense will occur in the ordinary course of events and have the mens rea for the principal offense.
由此可知
For example, in Ambidex
，SIS
B,
以射杀为原则，
we can see that
并且
the ABSS is used for
30
shooting,
秒的时间，
and the ABSS only have 30 seconds to decide whether to shoot or not.
不足以保证
And for us,
，ABSI
30 seconds
不会对被
cannot
害人
guarantee that
残酷的
the
杀
ABSS cannot be used on
也希望
victims.
各位法官注意附录 A 当中的
And
地
I would like to draw your attention to the map in Appendix A.
是为其女性发放旅行证件。
The Northerners refused to deliver travel documents to women,
莫塞罗斯的唯一
so
方式
crossing the river is the only mean
仅
to
仅是为了阻止
get out of the country.
那么完全可以采用个人
If
道路手
we
段
only want to
像欧洲采用
avoid illegal immigration, there's other means. For example, in Europe and US, there's obstruction walls and segregation nets. But in this case, they have used ABSS shooting.
阻止难民逃离性别隔
We
离
can
的
see
有关恶意。
that there is malicious intent to avoid the women get out of the country.
控被告
The third reason, the evidence in this case has substantial grounds to charge Vraga, and we will argue this in three ways.
本案报告的证明价值
Probative value.
不利影响。
Second, probative value outweighs prejudice. Third, the evidence meets the standard of substantial ground for belief.
本案的报告具有较高的
The first reason, the evidence has high probative value.
需要考虑
In assessing probative value, we need to take into consideration reliability.
是真实
Reliability requires that the purpose of the evidence be true, voluntary, and trustworthy.
全国性
In this case,
调查细致，
the International Human Rights Organization that issued the report is known for its reliability through its malicious investigative process.
在本案当中
So reliability can be guaranteed.
直接联系的内幕证人。
And in terms of source of information,
投案中
the Morgola and Shrek are insiders with direct ties to the defendant.
重要。
ICC considers evidence obtained from such witnesses to be crucial.
利于被告的公
Those two people are both employees of Raga Software
向人权国际
company,
提供相关
and they had no motive to work against the defendant.
此报告具有较
And
高的证明价值。
Initiative to provide information to the human rights organization was genuine and voluntary. The second
第
reason,
61条第5款规定，
the probative value outweighs the
可以无
prejudicial
预期在
effect.
时作证的证人。
The disappearance of witness at the confirmation of charges stage doesn't necessarily impair the probative value of the evidence.
也没有受到严重损害。
So even though witnesses disappeared, it does no harm to the probative value. The third reason, the evidence met the standard of substantial grounds for believing.
的证据
In Abagada case, the tribunal analyzed the following factors at the confirmation of charges date.
证据是
The material evidence was not contradictory,
本案中的报
the
告
evidence was specific, not general, and the evidence was substantial reliable, not speculative. In this case, the reports were based on publicly available information and interviews with insider witnesses. So they're not speculative or contradictory. So they have met the standard. Regarding the third issue, we are of view that Varga should be found guilty of a crime of obstruction of justice under the Article 71C. We have three reasons. First, we have meet the definition of the witness. And second, the conduct has meet the criteria of obstruction of justice. And third, the act of Varga has meet the standard of the psychological element. The witness, according to the statute, means that they have the information of the case, even though they do not testify in the court. In this case, the two witnesses have provided information to the NGO, so they have met the criteria of witnesses. And then behavior elements. The ICC in Bemba stated obstruction of justice should cover a wide range of conduct that can influence the testimony of a witness. For example, in the case of Matijet case, held a disclosure of information about witness that hasn't yet been protected by a court order is a form of interference with witness. In this case, Varga posting of information about witnesses, in this case on the CyberLeaks website, which is under his strict control, constitute a manner of obstructing justice. The act of disclosure can create a threat to the safety of witness.
I'm just wondering if we can consider this insiders as witnesses, if, according to my understanding, there's no witness statement on the record. We have an NGO report which was written on the basis of information provided by them, but we don't have any statements, witness statements on the record. So could you please explain why in your submission they can be considered witnesses in this case? Thank you.
Your Honors, regarding the third issue, the obstruction of justice, about the definition of witness, in Bemba case, ICC stated that under the Article 71C, the witnesses include the potential witnesses having their information, even though they're not in the hearing and they do not testify. In this case, the two witnesses have the information about the case, so they should be considered as potential witnesses. In this case, they have met the definition of witness. This is our answer to your question. In the case of Matijet case, the court reckons that the disclosure of information will create a threat to the safety witness and will exercise psychological pressure on other potential witnesses. At the outcome level, the ICC in the Paul Gichru case has held that constituting the offense of obstruction of justice doesn't require evidence to be provided that the act had an actual effect on the witness. Therefore, if it cannot be proved that the two missing witnesses were actually harmed, a Varga can still constitute the offense of obstruction of justice.
So should the chamber decide that Mr. Varga is not a member of a state party, and so applicable to the larger issues of gender apartheid, et cetera, what would it still allow us to consider the charge under Article 70?
In this case, first of all, regarding issue 1, we have stated that his nationality of Pendles should be recognized. So, under the Article 12, the ICC has the jurisdiction over the defendant. Besides, even though, according to judges, the nationality of Pendles of defendant shouldn't be recognized, the ICC can exercise universal jurisdiction under the Article 71C. There is the jurisdiction of rational personnel should have been used in obstruction of justice. So it's in our position that even though we cannot exercise jurisdiction under the Article 71K, we can still exercise the universal jurisdiction under the Article 70. So on the psychological or mental element, at the confirmation of charges stages in Paul Jichuru case, the pretrial chamber inferred mens rea from the perpetrator's knowledge that the conduct would influence and interfere with the witnesses. In this case, CyberLeaks has been used for a long time to publish classified internal documents, and Fraga is in control of the platform. So Fraga is aware that if the content is published, that it will be, in fact, on the victims. So in our position, we should ask the defendant to compensate the victims under the Article 75. First of all, they should stop using ABSS. Second, we should order the defendant to pay compensation for the resettlement, education, psychological rehabilitation, and community reconstruction of the victims. And third, the CyberLeaks should play its role in raising funds for the victims' trust. The trust fund should be used for rescuing the victims of gender apartheid, and the gender and trust fund and can be used for the historical archive of gender apartheid. So we should confirm the charges against the defendant. The ICC has jurisdiction, and the Defendants Act has violated the Article 71K, the Human Acts. And the defendant has already violated Article 71C, obstruction of justice, at the end of submission. Thank you.
Thank you, counsel, for the victims. And before I turn to the counsel for the defendant, can I kindly ask the timekeeper to show the sign of the remaining time to the bench as well, so that we can manage the submissions. Okay, the defense, you have the floor to give your arguments. Please proceed.
Your Honors, good afternoon. I am the defense counsel Li Jiayu. Beside me is my researcher Zhang Zixian. Here, we would present 3 arguments regarding the submissions from the prosecution. Regarding the first issue, pursuant to Article 12(2)b of the statute, the court lacks personal jurisdiction over the defendant. In this regard, the ICC should apply the principle of genuine connection to determine the defendant's nationality for the following 4 reasons. First, the provisions on nationality in the statute itself do not exclude the application of the genuine connection principle. The defense argues that the genuine connection principle should be applied under Article 21(1)b to limit the application of nationality. Second, the principle of genuine connection originates from the 1955 Notaban case of the ICJ, in which the court established the principle of abusing nationality, and so it could prevent illicit proceeds from abusing nationality. Therefore, this case has important reference value. Third, the principle of genuine connection is also a customary international law rule. However, it is only limited to diplomatic protection in the eye of prosecution, which is wrong. In the 2018 restatement of the Law of Foreign Relations of the United States, 4th edition, for the first time, it explicitly established the principle of genuine connection as a customary international law rule constraining the exercise of extraterritorial jurisdiction. The nationality principle is precisely a specific form of exercising extraterritorial jurisdiction. Similarly, in the cases of American Insurance Association et al. Versus Henry W. Lowe, Presbyterian Church of Sudan versus Talisman Energy Corporation, and F. Hoffman La Roche versus Emparam, the governments of Switzerland, Canada, Germany, and the Switzerland, and the UK and Ireland, and other countries stated in their amicus curiae briefs that the principle of genuine connection is a customary international law rule that limits the application of nationality principle. Additionally, James Crawford emphasized that if there is one emerging principle, and that is there must be a genuine connection between the subject matter of a jurisdiction and the territorial basis or legitimate interests of the relevant state. This view is also endorsed by scholars such as William S. Dodge, John H. Curie, Robert Jennings, and Arthur Watts. Furthermore, this is established in the ILC's 2006 report submitted to the UNGA on its page 521. Therefore, it can be concluded that the principle of genuine connection has been widely accepted by the international community. Therefore, Article 12(2)b of the statute should be understood as a nationality principle based on the principle of genuine connection.
Can I ask one question? You commented on the customary international law, and you understand there are 2 basic fundamental elements to comprise the customary international law: opinio juris and state practice. So can you elaborate more how the genuine connection principle has become the customary law in terms of these fundamental basic elements?
Your Honor, in accordance with the statute of ICJ, Article 38(1)b, the standard of asserting customary international law is state practices and opinion jury. The defendants would like to use the Article 38 1b. We use the opinions of experts in jurisprudence and international law. However, the authorities we have cited, such as the Reinstate of Foreign Relations Law of the USA, the 4th edition, is the most authoritative publication in this regard in the USA, and also it has a very important reference value when the US has its submissions. In addition, amicus curiae briefs also have referred to opinion jury. So that is my answer to your question. Also, I would like to respond to the cases mentioned by the prosecution and the common legal representative of the victims. For example, the Foreign case first. In this case, the mediation committee did not really deny the principle of genuine connection. In Nottebohm case, the condition of applying genuine connection is that Waternagan, he had the American citizenship. However, in this case, he, in accordance with the domestic law of the US, lost his American citizenship since he did not have the USA nationality anymore. Therefore, in this case, the principle of genuine connection could not be applied. This customary international law rule is not contravened in this case. Second, the protection and the victims team listed the case of diplomatic protection, and the commentary number 4 didn't really elaborate that the principle of genuine connection was totally invalid. Only when this principle is totally exercised, many refugees and migrants cannot enjoy any protection. In this case, the defendant has dual nationality, and that is in nature totally different from the cases they cited. Third, according to the Micheli-Talley case cited by the prosecution, this case dealt with an internal dispute among countries within the European community. So the non-application of genuine connection principle is to ensure the freedom of movement among all the nationals of the countries within the European community. So that doesn't involve the specific questions of the European community's legal framework. Also, they mentioned the Sabah versus Turkey case, which was an international investment case. And they cited the decisions, paragraph 75 and 76. However, this case did not deny the value of the principle of genuine connection in international law. It just used the rules of interpretation of treaties and conventions. So this case we are discussing is special. The case they cited is a representative of a Turkish company, and his Dutch nationality was arranged for convenience reasons. However, this situation is very different from the situation of applying genuine connection principle in this case. Next, I would like to argue the second issue. According to the Article 71K and Article 25.3c of the statute, the evidence and allegations of this case are insufficient to establish that the accused committed the inhumane acts of aiding and abetting gender segregation. Specifically, there are 3 reasons for this. First, the existing evidence does not meet the standard of confirming the charges. In its 2009 decision to confirm charges in the Bemba case, the ICC explicitly stated that the court cannot confirm charges against a defendant based solely on hearsay evidence or indirect evidence. This means that in the absence of any direct evidence, relying solely on hearsay evidence is insufficient to meet the evidentiary standard required to confirm charges. In this case, the prosecution's charges are entirely based on an HRI report, and this report constitutes rumors and hearsay evidence, not direct evidence from the prosecution's on-site interviews. Therefore, it does not meet the substantial grounds standard for confirming charges.
I'm sorry, counsel, I have a question. Why is the defense submitting that this evidence is hearsay? Could you please explain a little bit more why you consider that to be the case? Because I understand that the names of the witnesses are given, and they're given the information on the basis of facts that they themselves knew or saw themselves. So if you could explain that a little bit more, I would be grateful. Thanks.
In general, hearsay evidence is not made by the witnesses himself or herself. However, it is stated by someone else. If we look at Appendix B, paragraph 2 of the problem, HRI report was compiled according to interviews with 2 insiders and public records. These kind of reports are based on refurbishments and some rumors, so we see it as hearsay evidence. Before, ICC didn't preclude the use of hearsay evidence. However, ICC never really determined that there are substantial grounds for confirming charges based on only one source of hearsay evidence. Second, the nature of the acts in this case does not reach the same level of severity as other acts referred to in Article 7.1. First, the prosecution referred to the Ongwen case, but the severity of the acts in this case does not reach the same level in the Ongwen case for 2 reasons. On the one hand, the ICC has determined that forced marriage constitutes a fundamental deprivation of the victim's basic right, which is to choose a spouse. And the defendant imprisoned and repeatedly raped and beat the victim. Whereas in this case, the fundamental human rights of women, such as freedom of movement, were not deprived. On the other hand, forced marriage forcibly binds the victim into an intimate relationship based on spousal status, forcing them to remain in an unwanted intimate relationship for an extended period of time and fulfill marital obligations, which can lead to severe mental suffering. However, the acts in this case did not impose such intimate relationship on the victims, and the victims were not required to spend every day in close proximity with the perpetrator. Thus, not constituting the same severity level as in forced marriage. Secondly, regarding the accumulated suffering raised by the prosecution, the defense does not deny that severe gender discriminatory laws can constitute crimes against humanity. For example, in the arrest warrant issued by the ICC on July the 8th, the prosecution charged 2 Taliban leaders with gender persecution under crimes against humanity. However, there are 2 differences between this case and the aforementioned case. First, in the situation of Afghanistan, crimes such as torture also occur in conjunction with discrimination. However, in this case, there are no other crimes under the statute. Second, while the OTP mentioned cumulative in its application for an arrest warrant in the Afghan case, but the severity of this case falls far short of the severity level compared with the Afghanistan situation. Specifically, the Taliban issued 52 decrees, including restrictions on Afghan women's freedom of movement to the extent that they could not walk short distances alone, and even the most ordinary jobs, such as running a beauty salon, were prohibited. In contrast, this case involves only 4 decrees, and both the degree of oppression and the scope of application are significantly less than those in the Afghan situation. Therefore, the accumulated suffering cited by the prosecution falls far short of the severity required for criminal liability.
Sorry, Councillor, I have another question. So, are you submitting that the Chamber should not consider the flogging of the violators of these decrees in assessing the severity of this gender apartheid crime? Or what is your position in respect to that? Because I think that you were making reference to the decrees only, I believe. If you could please clarify. Thank you.
Flogging can be used as a means of punishment, like incarceration or other means. It is not a crime in itself. In addition, when determining whether there is severe psychological suffering, ICC also takes into account the physical reactions of a victim after the crime. This is demonstrated in Mosara case. In 2021, the court determined, yes, the charges were confirmed in paragraph 275 to 277. It was mentioned that the victims witnessed the murdering and dismemberment of their family members, so they suffered mental problems and disorder. Therefore, to answer your question, in this case, there's no evidence indicating that the victim's mental condition was so impaired to such level of severity. Third, the subjective element of aiding and abetting under Article 25(3)(c) of statute is not satisfied. Article 25(3)(c) of statute requires that an accomplice must not only be aware that the principal crime is likely to occur, but also must act with the intention of facilitating the commission of the crime. I would like to remind the court that if we look at the paragraph 8 of Appendix B, in this case, sorcerers paid 120 million for the installation of ABSS, which was merely a routine commercial activity of the software company with the sole purpose of commercial profit.
Furthermore, in Annex B, Section 10, which has been mentioned by the prosecution, this is the whole sense of the project. Now, it is clear that that is not the case in the case at hand. I refer to the Bemba judgment. It is not possible to infer subjective intention from one statement by the accused. A reference must be made to the whole scenario exchanged between them. It is impossible to infer the accuser's purpose from one utterance by them. Now, referring to the third issue at hand, in Article 71C of the statute, there's reference to obstruction of justice, and this is what the accused is also accused of. We would submit, however, that it is impossible to hold the accused's actions as meeting the subjective criteria. The prosecution refers to the Bemba case and the Jiqielu case, but we would reply that these cases refer to deterrence and creation of a climate of fear by continual control and surveillance, and indirect reference to negative consequences. Now, secondly, the Burjanin case, as adduced here, refers to a state of war where all witnesses who testified against the accused were seen as enemies. Furthermore, in the Ruto case, serious intimidation of witnesses took place during a period of civil unrest and intimidation within the borders of Kenya. There were negative media reports and a hostile attitude taken by the government of Kenya to the ICC. In the Haradinaj case, the background was instability in Kosovo, which was prejudicial to the witnesses. But the actions referred to in the case, even though they referred to direct statements made to the witnesses, they were not held to be intimidation, and thus the actions alleged in this case cannot be held as witness intimidation. Now, in the Antaganda case, an application was made for witness anonymity, but the PTC held that some witnesses were no longer in contact, and thus publication of their names would lead to their endangering. But the witnesses in this case live in peaceful Davos, and thus this mere publication of their identities cannot in and of itself lead to a risk of their disappearance. That concludes the arguments for the defense, and I respectfully request the court to give them due consideration. Thank you for your attention.
I believe important points have been raised in the statements made by each of you parties and participants. And each party will now be given, in the same order, the possibility to reply to it. I'd like to remind you to respect the time allocated for this exercise. No team will be given more than 5 minutes for their rebuttal. Counsel for the prosecution, you have the first floor. Please proceed.
Thank you very much, Your Honour. Firstly, on the issue of jurisdiction, as referred to by the defence, I would respond with one point. The rebuttals by the defence are used instrumentally and talking about the different purposes of the other cases relied on, and thus arguing that the Nottebohm case is not of application. In this case, interpretation of the jurisdiction case is in order to avoid impunity. Even in the Nottebohm case, diplomatic protection involved completely different interests, and though by the logic of the defense itself, the victims' counsel and prosecution's arguments are upheld. Furthermore, the prosecution believes the defense is guilty of a logical error throughout this afternoon, referring to dismemberment and other actions of coercion is a misreading of the principle of proportionality. A mere argument that the actions in this case were not as severe cannot be used to rebut the presumption of crimes against humanity. Furthermore, the key of this case is humiliation of women and forcing them into very unequal positions. And in the Vongel case, that is the same principle. In that latter case, a mere 5 cases of forced marriage were held by this court to be sufficient for the establishment of crimes against humanity. Here, we are discussing coercive decrees aimed at half of a country's population of 5 million citizens. Now, on the subjective elements, please refer again to the design principles of the ABSS. This has been discussed already this afternoon. The ABSS is a highly lethal defensive system and is clearly capable of causing harm over and above the provisions of the contract, and thus the subjective criteria for aiding and abetting are established. On the question of evidence, the defense has just submitted that in this case it is not possible to rely on one piece of evidence to support the accusations. In the Ntaganda case, it has been held that a statement by one witness can establish extraordinary circumstances. Now, in the Anda case, the court upheld evidence from one witness because they were a high-level member of the respective armed forces. Now, here, this is 2 witnesses of high positions in Virago Soft, and thus they are of probative value. Now, Bojaning and Nataganda have been cited by the defense, but these cases were not referred to by the prosecution. Furthermore, the defense argues that Magadici in the Balastici case, being held guilty of obstruction of justice and causing the witnesses to be unable to give objective evidence, and thus there is a clear relevance of that case to the issues at hand. we would respectfully request that the court take this into consideration. Thank you for your attention.
Thank you. Now, may I ask the legal representative of victims to present its observations? You have the floor.
Your Honours, Counsel for the Victims would make the following submissions in response. On issue number 1, we would like to offer 1 point in rebuttal. It has been argued that genuine connection has become part of customary international law, but as we have argued, that opinio juris is required as well as actual reference. We argue that in the 1999 Lagerland case, where Germany took the United States to the ICJ, saying that a German citizen had been sentenced to death in the US, but they were not entitled to German diplomatic protection. This person at hand was born in Germany, but moved later to the US, having at no point acquired US nationality. But the US argued that the person's body language and actions were similar to those of an American, and they were unaware at the beginning that they even had German nationality. However, at no point did the US refer to the genuine connection principle, nor did the court make a determination of Lagerland's nationality based on the genuine connection test. We're thus of the view that genuine connection has not become an accepted part of customary international law. Furthermore, even if the court holds that the cases cited by the defense conflict with those that we have cited, under Article 32 of the Vienna Convention of the Law of Treaties, this is still an unclear point. We can also look at the circumstances of the concluding of the treaty, in particular at the 46th report of the meeting of the parties in 1996. A description of the drafting process is given for the Rome Statute. It's mentioned that the place of commission of crimes may sometimes be unclear, but nationality is an important criterion for establishing jurisdiction, and thus nationality is a clear ground for establishing jurisdiction. If only one nationality is used and the genuine connection test is applied, this will be damaging for the stability of the court's practice. Thus, we would submit that the principle of equality should be used in order to resolve the stability of jurisdiction issue. On issue number 2, we would like to respond as follows to the defense's arguments. The defense argues that a crime cannot be established based on one piece of evidence, but the appeal chamber of the Special Court for Sierra Leone, this non-reliance on one piece of evidence is not grounds for rebutting a piece of evidence. And due to the relevant witness having died, their evidence was not corroborated by other pieces of evidence, but nevertheless it was accepted. Secondly, the Taliban regime issued 52 decrees discriminating against women, but we would rebut that the quantity of decrees does not of itself establish the severity of discrimination, and the actions of the Balaran regime in some respects go beyond what was done by the Taliban. The Taliban prohibited education of women beyond the age of 12. The Balaran regime prohibits it beyond the age of 8 for women. Furthermore, the Taliban has ordered that women cannot travel by public transport without a male person accompanying them, whereas the Balaran regime has completely prohibited women from taking public transport. We respectfully request that the court consider these arguments. Thank you for your attention.
Now the last word is from the defense. You have the floor.
Your Honours, in relation to point number 1, we would offer the 4 arguments. Extensive reliance has been given to the purpose of the statute, in particular ending impunity, but they have ignored the principle that jurisdiction of the ICC should not infringe on the sovereignty of non-signatories, and they've also ignored the fact that the ICC's jurisdiction is complementary to that of its signatories. In Articles 1 and 17 of the preamble to the Rome Statute, it is stated that jurisdiction of the ICC should be complementary to that of the treaty states. Only when one state is unwilling or unable to adjudicate on international crimes can the ICC take jurisdiction. Therefore, jurisdiction by the ICC must not be applied in an extensive manner. The accused in the case at hand was born in Pentos, but their home, family and economic links with Pentos do not exist. Thus, in the court's adjudication of this case, it should adopt a moderate approach, avoiding overexpansion of its jurisdiction. Furthermore, according to Article 12, one of the purposes of the statute is to respect the interests of non-signatories. If the court takes jurisdiction in this case, this will lead to situations where acts by a non-citizen of a signatory state committed in the territory of a non-signatory state are taken before this court, and that goes against the principle of respecting sovereignty. Furthermore, in the 2019 North Korea situation, the court again held that genuine connection could not be applied as a principle, and also held that individual determinations of nationality by states cannot be adopted directly by international courts. Finally, reference is made to the drafting process of the statute, but jurisdiction is only present in the drafting process. It was not finally adopted in the statute, and there are specific articles 13 and 14 with preconditions for the exercise of jurisdiction, which again shows the moderate approach taken to jurisdiction by this court in its practice.
方仍有2点的回应。首先，对于证据问题，一方面针对检方所提出的观点，检方和受害方所提的观点，证据的评估应当综合整体或整体平衡原则。
Counsels, just for a moment. We can hear the English interpretation. Can you start again for tell us your statement of the 15 minutes ago? 15 seconds.
Now, I would like to reply to the representative of victims. And she mentioned the history of a Rome Statute, and the ICC has exercised restraint regarding the universal jurisdiction, and we have a fierce debate on universal jurisdiction. But ICC didn't adopt a universal jurisdiction. About the Article 12, 13, and 17, in ICC has a limitation on jurisdiction. This shows that ICC exercised restraint on the expansion of a jurisdiction. Regarding the issue 2, the defense has 2 responses. First, about the evidence. And can we have 15 seconds more? In the case of Ruto and Sango, there are 5 witnesses and material and evidence. In this case, the nature of evidence is a hearsay, and the quality is not enough. And they insist on the ABSS and installation of the ABSS. And this cannot be considered as enough evidence. Thank you.
Thank you. The bench will now leave the courtroom to proceed with deliberations in our chamber. The bench will delve into the arguments provided by all of you, and then take a decision. So you will be allowed to leave the courtroom, but will need to be present here at 16:35. And thank you, court officer.
All rise.